All right, I think this is up. We are recording.
And that's why I love so great is like those people who like to argue for things.
Okay, all right, so you have a copy of discussion post number 2. Let's read discussion post number 2, and let's talk about how you're gonna go through and start doing the analysis, okay? Because when you look at the criteria, it's very specific. So can I get a volunteer reader? I know it's 8:30 in the morning. Nobody? All right, thanks, Molly.
When they start from the very top here.
No, just at the facts board.
Thomas Clemens.
Yes, ma'am.
Thomas Clemens brought an action in a court in Illinois to recover damages for breach of warranty against defendant Cigna Corporation. A warranty is an obligation that the seller of goods assumes with respect to the quality of the goods sold. Clemens had purchased a motorboat from Barney Sporting Goods, an Illinois corporation. The boat was manufactured by Cigna Corporation, an Indiana corporation, with its principal place of business in Decatur, Indiana. Cigna has no office in Illinois and no agent authorized to do business on its behalf within Illinois. Clemens saw Cigna's boats on display at the Chicago Boat Store. In addition, literature on Cigna's boats was distributed at the Chicago Boat Show. Several boating magazines delivered to Clemens in Illinois contained advertisements for Cigna's boats. Clemens also had seen Cigna's boats on display at Barney Sporting Goods store in Palatine, Illinois, where he eventually purchased the boat. A written warranty issued by Cigna was delivered to Clemens in Illinois. Although Cigna was served with summons, it failed to enter appearance in this case. The court entered a fault order and subsequently a judgment of $6,220 against Cigna. Cigna appealed. Decision?
All right, so what you're being asked to do is to analyze the issue in this case in terms of, so we have a company that's being sued, okay? What do you think they're, when you hear about this language about, well, they didn't have offices here, they didn't do this here, what do you think they're trying to suggest? They're trying to raise a jurisdictional issue. You with me? So on appeal, they're going to argue, well, wait a minute, this court never had authority to enter a default judgment because they don't have jurisdiction over me. With me? Is that okay? All right. So the first part of your discussion post should clearly state your claim. What do you believe the court's going to do? On appeal, the court should whatever. I am not invested in whether or not you produce for me what you think is a legally correct answer, like yes, the court's going to affirm this, or no, they're going to reverse it. You follow me? I am interested in your what? Your analysis. I want to see that you've taken us through the rules and you've applied the rules to the law, because we're going to all reach different opinions. Potentially, right? And that's okay, that's expected. That's why we have appeals. Because one party has one position, another party has this position, the court renders their judgment, their determination, and then we get to appeal, and then that judge could disagree with everybody and do something different, right? So your ultimate answer, not so much invested, just want to know what your analysis is, that you applied the applicable rules, and then you had a thoughtful analysis applying those rules to the facts. So let's break this down a little bit more. All right. So we got this Clemens guy over here. Who is he the plaintiff or the defendant? Plaintiff. He's the plaintiff. Okay. So as I'm going through and I'm reading this, I might just circle Clemens and I might just write something that tells me he's a plaintiff. Just so we can kind of keep this in order, okay? So he's going to follow suit in Illinois. So this is the place of the lawsuit, okay? And the defendant is? Yeah. Now, and the basis of this lawsuit is what?
Warrant obligation.
This warranty, breach of warranty about over this for what? A boat, right? So the lawsuit is about a boat. Breach of warranty. Okay? Now, he purchased the boat from an Illinois corporation. So that's going to be important, right? Okay? So the vote came from Illinois Court, Barney's. So it came from Barney's, which is an Illinois corporation. Okay? The boat was manufactured, however, by Cigna. So we're going to put it over here. They manufactured the boat. And where are they located at?
Indiana.
They're in Indiana. Let's pause right there. Can we sue them in Indiana? Could Clemens have filed his cause of action against Cigna Corporation in Indiana?
Yes.
Do we agree with that?
Yes.
Okay. All right, let's keep going. Cigna has no offices in Illinois. So over here is where the lawsuit is filed. He bought the boat over here, right? But we want to note that, so let's just, if we were to draw a map, or sorry, this is like this, here's Illinois. I have no idea what it looks like. Okay, so Cigna, not there. No offices, no agent. Remember that language that we said that a person or entity has to have with the state? What do we call that?
Long arm.
No, not long arm. We're told. But what do we say that we had to have in order for the court to exercise that authority? That's right. She comes in, she's already on a hot roll. As soon as she sits down, minimum contacts. Remember how we spoke about that? So that's why they're sort of emphasizing this, right? We don't have any contacts with the state. We don't have any offices there. We don't have an agent there. We okay with that? So that's why they're mentioning this. So we're going to put over here minimum contacts. Now we're not saying that we agree with this just yet, right? But what we're doing is thinking about the facts and thinking about what rules are going to apply to the facts here. We okay with that idea? All right. So minimum contacts. So what are we going to call Sigma Corp? Are they a resident defendant? Non-resident defendant? Non-resident defendant. So non-resident defendant. So we got a couple different concepts we're reading into the idea of non-resident defendant, minimum contacts, and then where we have a non-resident defendant, is there something under, as someone else mentioned earlier, that long-arm statute that will allow the state to reach out, snatch them, right, and allow the proceeding to take place. All right, so let's keep going here. Clemens saw Sigma's boat on display at the Chicago Boat Show. Where's Chicago? Ooh. Boats on display. Okay. In addition, literature on Sigma's boats was distributed. Okay, so he saw boats on display and literature about the boats. Is that okay?
Yeah.
Several boating magazines delivered to Clemens in Illinois contain advertisements. Ah, so literature, boats, and then we got some magazine advertisements. Clemens had also seen Sigma's boats on display at Barney's Sporting Goods. Okay, and then of course at Barney's because that's where he ultimately bought it, right? And Barney's is in Illinois. All right, let's see. A written warranty signed by Cigna was delivered to him in Illinois. So,
They knew he was in Illinois.
over there, they send him a warranty over here. Send, sign, warranty. Are we okay with this? All right. Okay. So when you start to do your discussion post, the first thing says, clearly stated thesis or central claim. And so we have to think about what the question is. The question is going to be, what should the decision of this Court of Appeals be? So that's all we're going to, you're going to work through your analysis, and then you're going to come back and tell us what your thought is about how the case should be resolved. The trial court should blah, 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 blah. That's the first part. 2, citation to relevant RCW or some authority for your position. So we've got all kinds of stuff that we've mentioned here. Minimum contacts, long-arm statute, non-resident defendant, due process. So all of those different things you want to find some reference to inside. That's the authority. That's some rules that you're going to be relying upon to do your analysis. Okay?
Say that one more time. Due process.
So minimum contacts, long-arm stat. Hopefully you stretched all this out in your notes here, man. That's why I went begged all these people to use
Brain's
their
a
computer.
little slow yet to like catch up. I feel like there's like a 10-second lag or something. I think. Like our brains are a little slow today.
Now remember, our case has to do with it. This is Illinois and whatever, but there are some of these, they're so fundamental, right? Due process is a federal issue, right? So we can use some federal cases to interpret this. So you're not going to necessarily be looking at Washington RCWs, okay? So make sure that it's applicable authority. All right. Well-supported and developed arguments. Well-supported and developed arguments. So well-supported and develop your analysis. Okay? That's that section. You need to have a minimum of 150 words.
Okay, we can go over that.
You can go over
How are we gonna
this.
do all this in 150
But
words?
well, it should not be 200 pages though, okay? You know what I'm saying? It's a discussion post, all right? But at the very least, but what I've seen in the past, you can't address this adequately if you use less than 150 words. Okay? There's just no way. All right, let's see. And then your formatting. Make sure it's paragraph structure. Make sure it's spelled correctly. Blah blah blah. Want to see an example of this?
Yes.
All right. Oh, here we go. Ebony, ma'am, will you get the lights on me? Thank you so much. Is that good? All right, we're good. You made it, hey!
Yeah. Sorry.
No worries.
Told you Wednesdays, you know.
Here you go. Switch it. One is on, one is out. And then I got the recording.
Okay, I got it. I'm only half hour out.
Yeah.
Thank you.
You welcome.
You got my email?
I did.
Okay.
All right. So let's look at an example. So what's the first thing? What's the first thing that you have to do? That's right. Clearly state your thesis of what do you think should happen? On appeal, the trial court should affirm the judgment entered in Clement's favor as the defendant was given notice and the trial court properly exercised personal jurisdiction. Bam, I know exactly what your argument is. Okay with that? This does not have to be your argument. You can disagree. You can say on appeal the trial court should reverse the judgment entered in Clement's favor, as the defendant was not given proper notice, or the defendant or the trial court did not properly exercise personal jurisdiction. Yes.
So both answers could be correct as long as you're.
I'm not going to tell you that. I'm not going to
That's the
tell
thing,
you
because you
that.
said because they were not given.
Analysis of course.
Yeah, all I care about what your analysis is. Because here's the thing. We know there could be a different interpretation because we got an appeal, right? You feel you with me? So I'm only interested in what is your process of analysis, because we can debate about the law all day. That's what makes it so interesting.
My question was, because it just mentioned, because they were not given proper notification, but it doesn't say that here, so we just, like, we can just conclude maybe they weren't because they didn't have somebody there? Because it doesn't state if they weren't given proper notification, we just don't know if they were or not.
Well, here's the thing though, the idea about personal jurisdiction. So the issue about jurisdiction, right? Remember how we tie this into the idea of due process, right? And due process means what? What do we say? We say it means two things. One without the other is meaningless. Notice and an opportunity to be heard, right? And so what they're saying is, let's back up.
It just says they didn't have anybody there.
Okay, that's you don't need to finish. It's what's in your.
Remember, so what they're saying is, I'm not here. I don't exist in this state. I don't have any offices here. I don't have any agents here. I don't have any minimum contacts. How can I be on notice and I could be sued? You with me? And that's one argument. But their argument potentially is this, right? If you're going to disagree and think that the court should reverse, then your argument is going to be there's no notice. They haven't established minimum contacts. In order for the court to exercise jurisdiction over a non-resident defendant, there has to be minimum contacts. Due process requires that. In this instance, it's not. I'm doing the analysis right here. In this instance, Sigma does not operate in the offices in Illinois. They do not have any agents in the state. They did not do any direct advertisement. All of the advertisement that the plaintiff relies upon is advertisement that was done by by a third party or something like that, right? So that would be that part. On the other side, I can come right back and say, actually, there is notice. While they may not have any offices or agents, they sell boats. Boats are advertised in magazines. There's a reasonable expectation that magazines are going to be distributed across the nation. You with me? So therefore, they should be on notice. They can be sued in any state. Additionally, they sent out the warranty. A warranty is a contract. The contract was essentially provided in Illinois, and it came from them. So that's what I'm saying. You decide, but either way, you have to go through the steps of the analysis. You're going to be looking at the same legal principles, but you could very well reach a different,
And you only want one-sided?
That's right.
You don't want to play devil's advocate?
I don't want you to do that.
I can do it.
Okay? Not for this point. I think you got enough to focus on with this right here. All right. But you can see how we did do that just a little bit. Because we said, even though they don't have any options, so we're conceding, look, yeah, okay, fine. But even though that, still XYZ. Yeah. Okay. All right with that? Okay, let's pull this back down and look at the examples more. All right. Under the 5th and 14th Amendment, why did the students cite the 5th and 14th Amendment? That's right. Each party is entitled to due process, which means notice and an opportunity to be heard.
This example of one, yeah, it's just we need to refer to it.
It is. I'll show you where. Thank you. Where a court exercises personal jurisdiction over a non-resident defendant, due process requires that the non-resident have minimum contacts. Minimum contacts can be established in a number of ways. This is what we talked about. Committing a tort, transacting business, insuring property, etc. in the foreign state. And then they cited some law. They cited some, a case, international issue. In the present case, the courts exercise the personal jurisdiction of the defendant. A non-resident corporation does not offend due process because, why does, here we go. They say the defendant does not have an office or agent. It does nonetheless transact and promote business in Illinois. Wait a minute, hold on a second. Although the defendant does not have an office or agent in Illinois, it does nonetheless transact and promote business in Illinois. Does it make sense? Yeah. Okay. According to the facts, we're applying the law to the facts, the defendant manufactured votes, advertisements for which were distributed in Illinois. Additionally, advertisements were placed in voting magazines, which were delivered to the plaintiff in Illinois. One of the most critical facts is that upon purchase of the vote, a written warranty issued by Cigna was delivered to the plaintiff in Illinois. Right? All of these factors support the court's authority to exercise personal jurisdiction over the defendant corporation, even though it's not physically located in Illinois. Okay. Because the court properly exercised personal jurisdiction and the defendant was given notice but did not appear, the default order was properly granted. Thus, on appeal, the judgment of the trial court should be affirmed. You all right with that? Yeah. Okay. So that's your discussion. So don't just copy this. You do your analysis. Take your position. Okay. All right. You okay with this? All right. Let me show you where to find this on our site. Let's see, modules. Oh, hold on one second. Let me do student view because we want to test and make sure that you can actually see it as opposed to me. All right. Okay, so now I'm in student view. I'm going to go over here and look at, oh, thank you. I forgot to look at modules. Oh, assignment review. So DP. Now, Courtney, are you going to be able to find this later?
What? Yes, sorry.
Okay. So everybody see? Yeah. Oh, hold on. Let's make sure it's working now. Okay, yes. All right, we okay with that? All right. Have you guys taken a look at the practice quiz? No. Let's look at the quiz real quick, okay? What is this? This is a practice. So there's a practice, and then there's an actual one, okay? The questions are pretty much similar, but it's so, let's just go to the actual quiz, okay? Because I want to demonstrate for you that these are not trick questions. They're just to make sure you're understanding material. They shouldn't be. Let's just see. Let's do it now. All right, so quiz number 1. Did I take out the time limit? Somebody told me to take out the time limit.
Is this time limit done?
Yes, perfect. Okay, so we did take it out. All right, good. So let's leave student view. Let's go to quizzes. Let's do a preview. All right. The U.S. District Court is a trial level court in the federal system. Is that true or false? True, right? Remember we talked about the federal system, the baseline level trial courts and the district courts. Venue has to do with which court has jurisdiction over the subject matter of a lawsuit. False. That's false. Venue has to do with location and convenience of witnesses, right? Okay with that? Yes. Service of the summons and a copy of the complaint on the defendant is sufficient for the court to gain personal jurisdiction over the defendant. That is so false. It doesn't make sense. And I'm going to tell you right now why we're doing this, because I think in your text, it actually tells you that it is sufficient, and the text that's wrong. We'll have moments where me and the authors of your text will disagree. This is one of those moments. Okay? Because we've spoken about that. In order for the court to have jurisdiction, you have to have personal and subject matter jurisdiction. Just because I give you some documents doesn't mean that the court has jurisdiction, right? Okay. Let's look at number 4. Watson crossed the center lane in his vehicle. So he's driving, he crosses the center lane. A few blocks later, he was involved in an auto accident and arrested for driving under the influence. The other driver, visiting from another state, had physical injuries and damages to her car initially estimated at $3,000, but is now expected to be somewhere in the area of $12,000. Are we okay with this so far? All but which of the following statements are correct as it relates to questions of jurisdiction? So all of these statements are true, but there's one thing that's not true. Make sense? Let's see. For the civil matter, small claims court may have been appropriate based upon the initial estimation of the other driver's damages. Do we agree with that? Do we agree with that? Come on, be confident.
Yeah.
Why do we agree with that? Because the initial amount was $3,000 and the cap for small claims court is $5,000. So that's correct, right? So we know that that's not going to be the one that we mark out. Let's see. For the criminal matter, a district or municipal court would have subject matter jurisdiction as criminal misdemeanor offenses are within their scope of jurisdiction. So for that DUI up there, could the district court handle that? Yes.
Yeah.
Could the muni court handle that? Yep.
Yeah.
A civil lawsuit involving $12,000 could be brought in district court. Is that right?
No, it didn't have to be over 75,000. No, that's not. No.
So it's right? Because what's the cap for district court?
Supreme Court.
That's right. So we can be in district court as long as it doesn't exceed $75,000.
Yeah.
We okay with that?
Yes.
All right, let's get back. Okay. For the civil matter, because the other driver is from a different state, there is diversity jurisdiction, and this matter could be filed in federal district court. What do you think about that?
Because all the
It has to be wrong. But why is it? Maybe I made a mistake. Maybe I need to fix this quiz.
Does that have anything to do, it doesn't matter if the driver was from another state because it happened in
But it's because of
the
the
state
amount.
he's in, right?
Ah, that's right. What do we mean for diversity jurisdiction?
75,000.
That's right. We got to have diversity of parties, so diversity of parties, and that qualifying amount of $75,000.
Okay.
Are we okay with that?
Yeah.
Yes. Oh, and the quiz is open book, right?
Yeah.
So you can look at your notes and things, okay?
So we can have this now.
All right. There is a dispute between parties about a contract. Generally, State A may exercise long-arm jurisdiction over the defendant in State B if the defendant once lived in State A. Once lived? Well, how long ago was that? Uses a product produced in State A?
Made the contract.
Made the contract in State A?
Yeah, made the contract, yes.
As relatives.
Has relatives in State A?
Well, that's nine.
Okay.
Well, at least he's got somewhere to
That's
say.
right.
All right. Question number 6 relates to what we're going to cover today in terms of evidence. So we'll skip over that one. If the plaintiff files first, the plaintiff, what did you say?
That is funny.
Okay. If the plaintiff files first, the plaintiff must serve at least one named defendant within how many days, or action is treated as if it was never filed?
20, is it 21 or 20?
90 days. 90 days.
There's some, oh no, it's when you reply.
90-day rule.
Sorry, 90-day rule. Okay. Are we okay with that? All right, you just throwing out numbers. 15,
I know
20,
it's
what do I-
22?
30?
You have to respond. Is it 20 weeks to respond?
So 20 days to respond.
Oh,
okay.
I think it's personal.
90 days to.
All right.
You're not being so this time.
I'm always.
So you get an idea of the type of questions here?
Yes.
Okay. All right.
I have a question after something. So.
All right. Okay. So that's our quiz.
Can I ask you a real quick question? About something similar?
Yeah.
That I just thought of that it's like I'm really curious about and I haven't been able to find the answer anywhere.
Okay. So you can ask.
Can't. 9 is false.
Well,
Well, it's civil, and it's about.
That's true. All right, so we're shut the quiz down now.
Yeah, we
I
need to
know,
make
I
six.
know, I wanted to see.
We're curious now.
All right, let's see. Under this type of jurisdiction, federal courts already hearing a matter for which it has jurisdiction may hear a state claim if that claim is based upon the same facts. Federal jurisdiction,
Federal jurisdiction.
personal jurisdiction,
I think
supplemental,
it's supplemental jurisdiction.
supplemental.
Yeah.
Okay.
Yeah.
All right.
I know exactly.
Okay. All right. Let's go to our material for today. Okay, but what's your question? Let's get
I
Courtney's
could always
question.
ask you after class, but I wasn't sure because it's kind of one jurisdictional. And it's personal, but so I was years back.
I tell you
what.
Only because we got a lot of material to recover. But if you want to ask me outside of class, I'm more than happy to. Is that okay?
Oh, it's just me.
Okay. Let's talk a little bit about evidence. The reason why we're going to talk about evidence in this class is because lots of times when you're filing these motions in civil practice or discovery, what we're trying to do is we're trying to get evidence, right? We're talking about discovery mechanisms. And then also, once we get that evidence, a lot of our motions relate to trying to exclude or admit that evidence. All right? Okay, so we kind of just need to lay some foundation. I don't expect you to become experts on evidence, just from our overview, but I do just want to give you some context, all right, a little background. I think we should. Let's everybody has copy? Okay. Let's see here. Investigation. So part of what we're doing when we're conducting discovery is investigating our case. And the objectives are, we want to identify and locate factual evidence. We want to find out who our witnesses are going to be. We want to see if there's an expert that's going to be appropriate and get an expert opinion if needed. Maybe we might be looking for some impeachment information. Okay, maybe there's something that's a little bit inconsistent. Maybe there's some reasons to question the reliability or the credibility of the witness. We also want to determine the sufficiency of the claims that have been brought or filed. We are preserving evidence for trial. And also trying to organize that, put in some sort of manageable order. Okay. So bottom line is, whatever we're gathering, hopefully, it's going to be admissible. Because it has to be, the only value it has to us is going to be if we can actually use it in our case. Okay? So the more you know about the rules of evidence, the more effective you can be for that case, for your client, for your attorney. Okay? The other thing, in terms of why you want to know about the rules of evidence, is because you don't want to be responsible for tainting something, or not responding something, or maintaining something properly. Okay? All right. So what is evidence? Evidence is a specific area of law that defines and sets the parameter for the collection and presentation of information to be used at trial. Now, your text tells you this is about truth and justice. That is subject to debate. But it is about fairness and safeguarding constitutional rights. What, you waking up now? Okay.
Oh, yeah. Yeah, I know.
All right.
You're the perfect first teacher.
You guys must love
For the day,
you must be
you know?
really good at reading stories to your kids too. Like you can
All right. So we okay with this?
Yeah.
All right. So we got two sources, okay? Two primary sources for our rules of evidence. We got some federal rules of evidence, and then we have our state rules of evidence. When you go back to look at these PowerPoint slides online, these color text, remember, those are hyperlinks, okay? So you just need to click on that and find a way to get there. Bless you, bless you. So now when we talk about evidence, we're gonna categorize this evidence, okay? So the first category that you introduced here is the idea of testimonial evidence. Testimonial evidence is exactly what it sounds like, testimony. What the witness comes to court, sits in the stand, and actually speaks out of their mouths. That is testimonial evidence, okay? All right. Documentary evidence. Paper. So here's the contract. Contracts, letters, the medical records, the banking records.
Photographs?
Documentary evidence. We're gonna get to that. Okay. Notice I don't have photographs here. I know, huh? Yeah, let's talk about that. Hold on. So documentary evidence. Okay, we okay with that idea? Next we have real evidence. The thing itself. She bashed him over the head with this stapler. Courtney, this is the real evidence. I didn't say Courtney.
I could though.
Okay, let's not try Courtney right now, okay? So the real physical evidence, right? The scar, the weapon. We okay with that idea? Okay. Then we have demonstrative evidence. Photograph, diagram. This is a depiction or representation of something. Are we okay with that idea? What's wrong? You're scratching your head. It's too hot?
Is real evidence same as physical evidence?
Is real evidence the same as what?
Physical evidence.
Physical evidence? Yes, we can call it physical evidence. Yeah. Yes.
Well, like what if you're doing like a boundary line case or whatever, and so the real evidence is the map, or is the real evidence the actual piece of land with the stake in it? Or is the real evidence the survey?
The real evidence would, in that case, the physical evidence is the land itself, but we can't bring the land itself into court. So then we produce a survey. The survey would probably be the actual survey itself, the documents and all that. That would be documentary evidence.
So,
okay?
But it would also be demonstrative.
And it could be done. If it's a picture, the report about the survey, documentary. The pictures and all that, whatever, right? It's going to be a demonstration.
Okay.
Is that okay? All right. Now, the only real reason why this has meaning to you, right, is because you just want to have a general sense of how this stuff is categorized, okay? We don't, if it's actually documentary evidence, whatever, right? We want to make sure that we're appropriately referring to it as such, okay? Ooh, excuse me. All right. The next concept you're introduced to is the idea of direct versus circumstantial evidence. Let's talk about this by way of this. Okay, I'm gonna go. We're in the library. No, this is a bank. It's a bank. We're in a bank. Y'all all tellers and customers. Okay. Ebony, I'm not gonna make you the bank robber. Don't worry. I'm not gonna profile you like that. But you're gonna be somebody outside. Okay. You're gonna be the witness. Okay. Molly, we're gonna make you the bank robber. Molly, but here's the thing. What you see is Molly going inside the bank like this. Right? Okay? Now, then inside the bank, now you're still outside the bank, okay? Right? Inside the bank, you hear gunshots. You with me? Yeah. And then the next thing you see is Molly coming back outside the bank. She got a big old bag of money. Okay? With me?
Yeah.
Now, is it direct that you saw her going to the bank? Is that direct evidence?
Yes.
Yes. Right? You with me? Is it direct evidence that you saw her come out of the bank?
Yes.
With the bag of money? Is it direct evidence that she robbed the bank?
No.
No. It's circumstantial.
Yep.
Is that okay?
Yes.
Because that you didn't actually see.
Yeah.
You're just inferring that from what you did see. Are we okay with that?
Oh, yeah.
All right. Now, which one has more value? No, I don't.
Really?
No, I don't.
So, no.
No.
Really?
Really?
So what you see is worth less than what you thought you saw.
That's not what I said.
Depending.
Okay.
That's not what I said.
Depends,
All right.
right?
I said which one has more value.
Oh, well,
No distinction.
yeah.
No distinction. So, direct evidence is directly observable, proves the truth of the matter asserted. Circumstantial evidence suggests the existence of some other occurrence or thing. Is a reasonable inference from what you saw observed, okay? But there's no distinction. This right here is your Washington pattern jury instruction. So this is a jury instruction that your jury panel is given. Why is that? Oh, here we go. Oh, it's not supported. Oh, really? Okay. Washington pattern jury instruction. And here we go. I'll fix that link for you guys, okay? And I think it's 3 point, what is it? 1.0, thank you, 1.03. Ooh. Oh, really? Come on. Why is it messing with me this morning? What?
Oh, it's because it's Internet Explorer.
That's what I was just, yeah, let's try a different browser.
Terms of Internet Explorer supposed to be, and then it's like.
Now let's see.
Yeah, Firefox or Google Chrome always work.
I love Google Chrome.
As long
Here we
as
go.
it's not Internet Explorer, it's fine.
Oh, yeah, gotcha. Okay, here we go. And thank you, I'll fix that link, okay? Actually, I need to make a note of it. And the definitions, I'm working on that. All right, let's see. All right, so here's the jury instruction. The evidence that has been presented to you may either be direct or circumstantial. The term direct evidence refers to evidence that is given by a witness who has directly perceived something at issue in this case. The term circumstantial refers to evidence which, based upon your common sense experience, you may reasonably infer. The law does not distinguish between direct and circumstantial evidence in terms of their weight or value. One is not necessarily more or less valuable than the other.
Why not?
Yeah, why not?
What?
I mean, how are you gonna?
I should say
Well,
one
I
necessarily.
Well, here's the thing. It doesn't necessarily mean that what this testifies about is going to be automatically deemed credible, right? It doesn't mean that when the counsel gets up in closing statements that they can't argue, well, look, members of the jury, you know, you have to sort of evaluate and assess, is this really reliable? She didn't actually see this, right? The other side's going to say, well, you know, it's circumstantial, but hey, circumstantial, but you get to go back to that. Okay?
So,
Yes, please.
I understand that what you see is direct evidence, but what about all your other senses? Like I smelled bleach.
That's direct.
So all of
You smelled it. That's direct.
and like you heard gunshots, even though you weren't directly there, you're saying you heard the gunshots.
You heard, that's direct.
Okay.
But you can't say that you saw it. That's circumstantial. You can say that you believe that she did it, that whatever, right? But even you might get an objection on that because you say you're on lack of foundation. They didn't actually do whatever, right? So you can say, talk about what you saw, what you smelled, what you tasted or touched, right? All that's direct. Okay. All right. Admissible evidence. Only admissible evidence can be presented, okay? So we start out with that presumption. It's got to be admissible, okay? Then it goes, well, what makes it admissible? We're going to talk about that. In order to be admissible, it has to comply with the rules of evidence. That's why we're going over the rules of evidence. All right, so here's some of the basics. So here's where we start. In order for the evidence to be admissible at a baseline, it has to be relevant. It has to be relevant. Why do you want to talk about whether or not we're green today? What does it have to do with whether or not I shot my husband? It could be relevant. But you have to say that. By the way, he's still living right now, so don't close to the search party for him. All right? So at a baseline level, in order to be admissible, the evidence has to be relevant. okay? The presumption is that if it's relevant, then it should be admissible. Now we're gonna talk about how, yeah, even if it meets that threshold, it can still be excluded on other bases. But baseline level, in order to be admissible, it has to be relevant. The presumption is if it's relevant, then it's going to be okay. All right. So now we need to define, well, what the heck is relevant mean? Any tendency. Is that loose what? A looser way?
Yeah.
If it has any tendency whatsoever to make a fact more or less probable, then it would be without the evidence. Does it have any relationship at all? Can we show that? If so, we're going to say it's relevant. Is that right with that? And then there's some links to that provision. All right. Inadmissible evidence. So some evidence, even though it's relevant, right, may still nonetheless be excluded because if its probative value is outweighed by other factors. Okay? What do we mean when we say probative value? Probative value. Counselor, I'm going to exclude that evidence. I don't find it has any probative value for this case. Yeah.
How much, even if it's important, the value of, even if it really has some relevance to the case, it could be.
It's not gonna help you come up to the.
Yeah, right. So when we say that has probative value, right, it has some sort of importance to the case. It has some sort of significance or meaning for our case. And what we're saying here is that yes, this item that you're offering, yeah, it does have probative value. It's relevant. But nonetheless, what we're saying is that it might be excluded because its probative value is outweighed by some other factor. That other factor could be that maybe it's highly, highly unfairly prejudicial. There is no way this should come in. Maybe it has probative value, but this might just be confusing. It's gonna waste the jury's time. We're not gonna sit here and go through this. Maybe, well, we can see how it could be relative, but this is gonna be misleading. Or, counselor, you don't need this. We've already had testimony about this. This is cumulative, it's duplicative. We don't need to continue to go over this again. You all right with those examples? All right.
So, the truck driver from Walmart that caused that huge pileup in New Jersey that almost killed Tracy Morgan, Walmart is now trying to blame his injuries on the fact that he wasn't wearing his seatbelt. Is that probative value?
It could be. It could be. So it's a little bit beyond the scope, but I think I can bring it in. Okay. So did everyone hear the question? So Tracy Morgan, a famous comedian, was injured in an accident.
Yeah.
Okay. The defendant is trying to introduce evidence of a seatbelt violation. You with me? And the question is, well, would that be relevant? If I'm on the other side, if I'm the defendant, I'm going to argue absolutely it's relevant. It's relevant to the extent that it may go to his contributory negligence. Perhaps if he had been wearing a seatbelt, then the extent and nature of his damages might not have been so extensive. Say, for example, that I don't know all the nitty-gritty material facts of it, but let's say that he made contact with the windshield. You with me? Maybe I'm going to bring in an expert who's going to say, well, hey, that's seatbelts. Had he been wearing his seatbelt at this speed and this impact, what we know about the way that they work, if they're working properly, is that a seatbelt would have held him in a reasonable position such that he would not have made that impact with the windshield. So I'm going to argue, I love Tracy Morgan, but that might be something I'd be on the other side with, right? Does that make sense?
What's unfair prejudice? Like, give me an example.
Unfair prejudice. Oh, I love this AAG. He is like one of my favorite AAGs. He was prosecuting a case. I want to say it's the Judge Heck case, the judge in Pierce County who was engaged in some very inappropriate criminal activities. Oh, I'm not plugged in. Hold on one second. He said inappropriate and criminal activities, and he was being prosecuted. Hold on one second, you guys. Okay, am I in now? Okay. Are we still recording? Okay. And during closing argument, he posted a picture of the defendant, and superimposed on the picture was the word guilty in red letters.
Wrong.
The court said that was unfairly prejudicial.
Yes.
You with me?
Yeah.
So, and that's just one example. What constitutes unfairly prejudicial, it's going to vary by the facts and circumstances of the case, okay? Because the court's going to go through that analysis. Is it relevant, right? And then if it is relevant, you know, is its probative value outweighed by one of these factors? Because here's the thing, my classic argument all the time as a prosecutor, when I got a motion about is something being unfairly prejudicial, my classic argument, of course it's going to be prejudicial. We wouldn't be here if I didn't have prejudicial evidence against the defendant, Your Honor. You know what I mean? Yeah. But the question is it true? Is it just does it just tip the scale? Am I okay with that? All right. Let's keep going. Unfair prejudice. Here's another example. In a personal injury case, evidence that the plaintiff had once had an abortion. Come on, this is a car accident case.
Yeah.
Why do we have to talk about whether or not I had an abortion? You see what I mean? What value does that have, other than you trying to inflame the passions of some jury members who may seek, you know, who may feel a certain way?
Get dropped before because of the relevance issue.
Huh?
It wouldn't even get to unfair prejudice, would it just stop at the relevance?
Well, see what happened, we have a case about it. So that's how we know that at some point in time, something happened where this was let in and then we had to appeal this issue or something like that. You know what I mean?
Do you have to before even trials start, you have to present all of your evidence before you can use it?
We don't have to present all our evidence. No.
But you have to okay it with the judge. I don't know.
Yeah. Okay. So we're going to do some discovery sharing. We should be sharing our information, right? Okay. And we'll talk about that in terms of what our mechanisms are, what the timeline is, and all that kind of stuff. Yes. And so, one of the things we are going to be doing that's kind of relevant to this is, especially in civil practice, these motions in limine. We're going to be moving before trial starts, before we even have a jury, to exclude some of this stuff. Okay. All right. And a wrongful death action. Evidence that the victim had been driving without a driver's license.
Yeah. Still died. Yeah.
Right? Now, it'd be different if we were talking, if it was a wrongful death action, driving
driving.
case, he was under the influence,
Yeah.
we had taken some prescription medication with me, but then I don't have a driver's license. What are you
Even
trying
if you have one,
to?
would it have changed the fact he's not?
Right.
Yeah.
Okay. So you get some examples. Are we okay with that?
Yes.
All right. Some examples of confusing or misleading. The trial court excluded evidence of a settlement agreement that had disposed of some, but not all of the claims in the case. On appeal, the court ruled that this was proper under ER 403 because such evidence would have been confusing to the jury. So here we are, we had a whole bunch of claims. We were able to resolve some of those claims, so we actually settled on those things. But there's some other claims that we didn't agree on, and so we said, hey, we're just going to proceed to trial on these other things. And so now what you wanted to introduce is evidence that we settled those other things. And we said, no, that's not relevant. That's confusing. Right? Court said, yeah, we agree. So that's an example of an exclusion proper based upon it being confusing or misleading. All right. Next concept we're introducing is the idea of character evidence. Are we okay, guys? Yes. Evidence of a person's character or of a particular trait offered as proof of that person's conformity on a particular occasion is inadmissible. Yeah.
Like if they're KKK kind of thing, and they couldn't say they were like KKK.
Well, I have to be able to say it's wrong. So what we're saying here is that do people change?
Yeah.
Can people change? Did you guys ever see that movie? Did you guys see that movie 16 Blocks?
Yes.
Do you guys like action movies?
Yeah.
Okay, I love that movie. It has like Bruce Willis and this rapper Mos Def in it. It's really cool.
Oh yes, it's okay.
Anyway, Mos Def's character, as he makes this big old thing, people can change, you know? Anyway, but people change, right? Just because I did something Monday, Tuesday, and Wednesday doesn't mean that when I got to Thursday and Friday, I did the same thing. You with me?
Yeah.
Just because I may have done something in the past doesn't mean that I do it now in the present. And so the idea here is that my character, the idea of my character, you should not be able to use that to sort of say that just because I was one way at one point in time, that means I'm always that way. You need to present some fresh evidence that's relevant to what I am right now. Okay? Now there get some exceptions. Because in the law, we're always going to have exceptions. Character of the accused. Where evidence of a pertinent trait of character offered by an accused or prosecution to rebut the same. Now, what we're saying is that generally, you can't come in and parade all these people and talk about, oh yeah, this is how she is, right? No. But however, what this is saying is that once you actually attack it, once the other side has asked some questions to attack my character, now I can come and introduce evidence to refute that. Because now you've sort of set the stage, and so it will be unfair for me not to have the ability to respond.
All right, so they opened it up too.
That's right.
Okay.
And think about it this way. Angela, whether or not you stole that $500 bag from Macy's we're going to say arguably, doesn't really have to do anything with what kind of PTA member you are. Okay? We think you're a wonderful PTA member, but you still stole that damn bag from Macy's. You with me? Cares.
But you can use the fact that she's a kleptomaniac, a proven thief, as part of that.
No, I can't. Why? That's the same thing. That's the same thing. Okay? All right. Okay. Habit, repeated response to specific situation. Routine, same thing, but used in context of business or organization. So, evidence or habit or routine, by generally admissible. Let me give you an example of this. When we talk about maybe a business practice, maybe I process some sort of documents, and so I could maybe my testimony is about our normal process. Business context, we're going to use the word routine. Our normal routine, when we see this type of document in our office, what we do is we date stamp it. Once we date stamp it, we then go to our computer and we search by alphabetical whatever to pull up the client's name. Then we cross-reference that document with their file. We put the file number on there. Do you follow me? So that's that's admissible. Okay. Settlements, compromises, remedial measures, generally inadmissible. We just had an example of that, right? With the settlement thing, they wanted to offer that. No, not. But what if, let's say, let's say it's a suit against the state, the Department of Transportation, and maybe it's because they didn't have a proper barricade, or the barricade should have been replaced. There's a car accident, woman slips in the barricade and sort of falls off. If the barricade had been properly maintained, then she wouldn't have gone off the cliff. This is really tragic, okay? So immediately after this incident, the Department of Transportation, they fixed the barricade. So now, do you get to introduce the evidence that they fixed the barricade? Nope, you do not. Remedial measures, actions taken to correct something. Because we want people to do the right thing. If there is something that can be done better, then fix it. But we don't want that to be taken as an admission of guilt. You could still think, no, it's not our fault. We don't have liability here. However, let's try to prevent these issues in the future and fix it. All right?
That sounds guilty.
Okay, are we okay with that idea? Okay.
Yeah.
Past sexual conduct or sexual crimes. Generally, evidence of a victim's past sexual conduct is not admissible. Okay? We okay with that? Rape, we've heard of the idea of rape shield laws. Okay? So generally, idea of a victim's, evidence of a victim's past sexual conduct is not admissible. In a civil case alleging sexual assault or molestation, evidence of the defendant's past sexual crimes is, however, admissible. Okay?
Not their conduct,
Huh?
but not the past sexual conduct.
No, that's exactly what this is saying. So in a
I'm
civil
talking about the
case,
first
evidence of the defendant's past sexual crimes is
But
admissible.
only if they're found guilty, not if, like they did tried before, but they were found guilty. Could you then still put that in, saying, well, but they've been accused
Bring up
before,
the
they've
next-
been.
It depends. Let me give you an example. And it's really very. I think the best example I can give you is the sexually violent offender cases. Those are civil cases. They're what we call quasi whatever because they kind of have a criminal component to them, but nonetheless they are civil proceedings. Okay. And those cases where we are alleging that the person needs to have some treatment because they have a mental abnormality that makes them prone to engage in violent sexual whatever. We introduce evidence not only of their charged and convicted offenses, but other incidents as well, even if they were not charged. So now the question, there's a jury instruction that we give in terms of whether or not it's substantive evidence or whatever, that's a little bit beyond the scope, but nonetheless, yeah, it can set them in, but not just a crime or a conviction. So, general idea, victims past, no. Civil case, defendants past sexual crimes, likely yes.
So the sexual one, so the victim, let's say she had consented to, like, let's say she was a minor and she consented to sex. You know, let's say she got raped. The fact that she consented to sex before is admissible. Even though she's the victim.
With the same person?
Yeah, we can say it's the same person.
No, what you say is the same person. Does the fact say it's the same person? I mean, because remember, this is not going to be just a hard yes or no. The court is always going to go to the analysis, right? Well, first of all, is it relevant? How is that relevant? Because if because here's the thing. Can you at one point in time, and this is a sensitive subject, but can you at one point in time have consented to engage in an intimate moment with the person?
Oh, yeah.
Right?
Yeah.
But can you at another point in time say no? No, damn it, no. Right?
Yeah,
and that means
you say
no. Right. So it's going to depend upon the facts and circumstances. Does that make sense?
Yes.
Okay. All right. Illegally obtained evidence, as in criminal cases. In a civil case, evidence can be excluded if it is illegally obtained. Okay, so somehow somebody's rights are violated, it's improper. Same goes in a civil case too. Okay? Privileges. You guys, do we need to take our break?
Yes.
Okay, you guys gotta remind me, I'm so sorry. Let's take a break right now. This is a good place to break, okay? Ooh, excuse me.
What are you doing over there?
Oh, hiccups, my bad.
Yeah.
No.
So, good news for me?
No.
No.
No. Not yet.
Not yet.
Not yet.
Um,
But that's what I'm doing now.
Are you?
Yeah.
That's funny that I asked. No one's gonna be back, girl.
I don't know. I don't know everything that I had.
Ah.
I don't know, dude. Really?
Yeah. You know how those dudes are using, but yeah.
I know, I'm always in the way. I take up more space than this ever offers me.
Just get it out of the way.
I don't know.
Just get it out of the way. Look at like.
Do we have a discussion post for intro to criminal law?
Oh, really?
I have to look, my guess is that you didn't have those every week.
Yeah.
Nice.
Let me see, I'll look.
You just-
But that's on my list of
Yeah, based on what we went over, I was like, we kind of went over some stuff we did this. A little bit, yeah, a little bit, so, yeah. That was the question I asked you, not you both.
Yeah.
If there are assignments that cross over for both classes, do I need to
There
separate?
aren't.
Okay.
There aren't.
Okay, that is separate. Because then there's another class that was 106 and 154. People that are taking 154 guys were before. I guess some of these are exactly the same, like 106.
Yeah, and then he was like,
So they just submitted them again.
wait.
I want you to just.
You should have to type only one.
Might want you to.
That's probably a mistake.
Yeah, no, well, he doesn't matter, he doesn't remember anymore.
No.
But he started like escalating some of that weird stuff, and then I told you what happened.
Yeah, oh yeah, I know.
Yeah,
That's
so,
not right.
he's never done that before, so I'm being very cautious,
Hopefully when we visit him.
but, yeah. I have, it's really,
That's good. Of course, it's, mine's just doing messages. Well, it's, I wish they could do it now. I have no clue for it at all. Yeah. Use my pretty hard about.
yeah.
Give them money, whatever. She asked me for like a couple of bucks.
Yeah, no, it's crazy.
It's not like you got married.
That's true. I know, and I understand that, but
Like I said, I'm going to do it. Go over to house, I'm going to
Yeah, but I don't know how it's usually they get this cases from the so I'm not sure how
yeah, no. You're gonna get a weird photo. Protect.
I don't know. Maybe.
Oh my god.
I was ready to go, but I wanted to do it.
Yeah.
That's what emotional.
It just rolled out. Yeah, like you just do your analysis. It's just when you have a case, it's just makes your argument stronger. Because they're going to tell you that. That you can argue.
Yeah.
Well, I'm just saying.
We were cool, we were good friends.
PCC versus this pay, this
Yeah.
have the same argument. I was the judge.
I was like,
I can see you.
So it's just like,
finally.
just personally.
Are you kidding me? Sorry.
Yeah.
No, I'm getting, okay, so for the longest time, all your academic degrees and all that kind of stuff, it's kind of been in like in an envelope, the original envelope,
Yeah,
they're
yeah.
mailed in, in a box.
Yeah.
And I cleaned my office and my home out over the weekend. And my husband was like, can we do something with this? So I took him to get him, what's it called? Framed and matted and all that kind of stuff. It's expensive.
Yeah. Much better do it yourself.
I'm like,
Yeah.
this is like
Yeah,
some of the
do it yourself.
tuition.
Yeah.
Go to Michael's, get your own, it's so much
Oh
cheaper.
my God.
Walmart gives you a couple, $3-4 picture frames.
Okay,
This
let's
is
see.
something extra special to you, then it might be worth it.
Not really. I just wanted you to take it up.
Yeah.
Okay, just kidding.
Go to Walmart and
yourself.
buy those diploma frame
Yeah.
Or even like the dollar store has some
And we
decent
can
ones.
tell.
Oh, come on.
I'm just
All right.
saying.
Are you ready?
Coming up from that, but.
All right, let's get going. You guys, it's 8:30. I know we start at 8:30. This is probably not the juiciest material,
It's interesting though.
but we got a little bit more to cover, okay? Okay. Let's see. We have this idea of privileges. So certain communications of confidential nature, or basically they're going to be protected. And if it's protected, that means we're going to say it's not admissible. Okay? And a lot of these you've probably heard of before, like the attorney-client privilege, right? Priest, physician,
Social worker?
social worker, client. There's a question mark here.
Yeah.
Why put why put a question mark there?
Because if the social worker hears something like
That's
abuse or
right.
something.
That's
yeah.
right. So that mandatory reporting
Yeah.
thing, so
Yeah.
iffy there sometimes, right? Husband, wife, except for there are exceptions here. DV.
Yeah.
DV issues.
Yeah.
Okay.
Oh, domestic violence.
Yeah. Domestic violence. Okay. Fifth Amendment privilege. All right. Let's see. So that was pretty simple. Now we get to the idea of witness testimony. So then we're talking about evidence, what's admissible, right? The other kind of rules of evidence and the parameters in which we have to operate. So witnesses must have first-hand knowledge. So you're on the stand, giving testimony. It needs to be something that you witnessed firsthand. Now, it can still be circumstantial, right? I heard this, I saw that, I think this, right? But you gotta have some firsthand knowledge, okay? So, you saw it, you heard it, you smelled it, you touched it, you tasted it, all that kind of stuff, okay? Common objection if we don't have this, lack of foundation. So when you're watching those lawyer shows, or you're in court and they're talking about a witness, and wait a minute, objection, you're on a lack of foundation. How does this person know this, right? Witness was not able to testify about what had occurred at a meeting because he had not been present at the meeting. So here's an example. So we got a case because somebody tried to do this. And the court said, no.
You weren't even there?
Sir, were you at the meeting? Huh? No. Then you can't tell us what happened
Oh, I
at the
find it
meeting.
funny.
Okay? All right. Opinion testimony. Do we all have opinions?
Yeah.
Yeah.
Oh, yes. Right?
No.
Oh, we got many
Everyone
opinions.
has opinions.
I think
Everybody.
that's probably why most of us are going into this trade.
All right. Okay, so a layperson. Layperson, so common, what are we going to colloquially refer to as common folk? Plain people. Right? Layperson. We can give an opinion based upon perceived facts or based upon a skilled lay observer. Okay, so a skilled something. So as long as it's rationally based and it's helpful. But it can't be based upon scientific or technical grounds because once we start to move here, this moves into a different rule that we're going to talk about in a few slides. Okay? So let's kind of flesh this out. Let's say it's a DUI case in a criminal arena, or maybe it's a negligence case in the civil arena, all right? Either way, we have a person who's been called as a witness for either the state or for the plaintiff, okay? And this person is a bartender. And they are being asked questions about, okay, well, did you see the defendant? You know, how do you remember seeing this person? Do you recognize the person in the court? Blah, blah, blah. When did you see them? What were you on shift? What were you doing? I was a bartender. Blah, 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 right? And ultimately, what we're going to get to is a line of questioning about whether or not this bartender observed this person or how they observed them to be acting. And if they, you know, thought they were under the influence or had too much to drink. On the other side, we're going to get what? Potentially, we're going to get an objection, right? There's the objection on a foundation. How's this person going to testify? This is a lay witness. How do you testify this, right? Well, so if I can inquire further, I'll lay some proper foundation, right? So play with me. You're a bartender, okay? So, ma'am, how long have you been a bartender?
5 years.
5 years. And how long have you been a bartender at this particular location?
2 years.
And as a bartender, have you had the occasion to observe individuals who've consumed multiple drinks?
Yes.
Do you know what we mean when we say under the influence?
Yes.
This probably might be, I've been particularly a little bit better, right? What are some of the signs that you have had experience of with people once they started to consume a little bit too much alcohol? What have you noticed?
Slurred speech, stumbling.
Slurred speech? Stumbling? Anything else?
Loud.
They're a little bit loud,
Argumentative.
belligerent, red eyes, okay, dilated, okay.
Falling asleep.
Now let me back up. Earlier, we spoke a little bit about your training that you had as a bartender. As a part of that training, did you learn anything about recognizing the signs of when a person had perhaps consumed a little bit too much?
Yes.
You follow me? So now we're laying some foundation, right? So she's not an expert, right? But now we're saying that she can testify based upon her skill set. She's a bartender. I bartended for 5 years. I've happened to see a few drunk people in my tenure as a bartender. I think I can recognize what they look like. And that defendant over there looked like he was speaking, right? Yeah. You get my gist, right? Okay. Let's keep looking. Now, expert testimony can be a little bit different. Expert testimony, what we're saying is there's some scientific, technical, or some specialized knowledge that forms the basis of this person being able to offer an opinion or some information, okay? And we have to say that it's going to assist the trier. Who's the trier of fact? Who's the trier of fact? What do we...
Who's the trier of fact? Judge?
Oh, that was interesting. Yes, if we're in bench trial, the trier of fact is our judge. Jury trial, our trier of fact is our jury. Yeah. Okay? So what we have to say is that this information or testimony from this expert will assist the trier of fact to understand some evidence or something that's relevant in this case. Okay? And that this person is qualified based upon their education, their skills, and their training. So they can speak with some knowledge about this particular subject matter. Okay. Can I bring the person in just because they're smart and charismatic? Maybe they're a little easy on the eyes of the jury and it's a boring trial. No, I have to make sure they're actually going to be relevant and they're going to actually assist the jury in understanding some piece of evidence or testimony that's relevant to this case. Yes, ma'am.
But you also have to make sure that they are a good teacher. I mean, you can't just pull in Mr. Joe Schmo expert and have him just babble to the jury.
Right, so that's
to be able to teach the jury.
I think that's a great point. That's a witness prep issue. That's not a rule qualification issue, though. But we want to do both. You with me, though? So now, this is a great expert witness. They're smart. They know about the issue, right? They're going to help the trier of fact, right? And they're also going to be just a great witness. They're going to talk to the jury in a way that the jury understands them. That's great, because you get some of these experts, and they meet all this criteria, but they suck. They're so boring and dry, and then some of them are kind of a little arrogant, and they don't talk to the jury, you know? So that's a witness prep issue, right? And sometimes, in some cases, we have gone with the other expert because, okay, we thought, well, yeah, this person meets his credentials, but they're also just very easy to understand. Right? This person might have a little bit more, they have some publications and all that crap. But this person right here, they only have 2 little bitty articles, but they meet all the other criteria and they're just so nice. And the jury will actually understand them and maybe even like them. Right? So you follow me? In terms of this criteria, we got to meet this. Okay? All right. Let's see here. State rule. So we have a state rule, and we have a federal rule. Oh my God, okay, so, I'm sorry, I have to go back to this. We had this case where the guy, he was claiming that he had been injured on his job. No. He had an injury, but then what happened was, he was working under the table and he wasn't supposed to be working, and he fell off this, what's that? It's called the scaffolding? Yes, right? And he like crushed his ankle and he injured his back, but he came back to get some more treatment. He was saying, oh, I don't know what happened. You know, all of a sudden my back just started aching all over again. And we're like, and nothing happened in between that time? No, nothing happened. Anyway, so our expert was this biomechanical person. What's his name? He's at the UW. But he was so brilliant. He was like talking to the jury, trying to sort of explain the mechanics of the body and the impact and force and all that kind of stuff and how it could produce this sort of injury. And he would look up at the judge and say, Your Honor, do you mind if I get down? And like without even direction, like we didn't even have to really direct or ask him questions because we just asked him one and he just kept going. But it was so nice. You could see the jury like they were following him, and he laid down on the floor and he's like, see if I do this, and you know, it was crazy. But occasionally you get those experts who are just awesome like that. All right. So our state rule. If the scientific, technical, or other specialized knowledge will assist the trier of fact to understand the evidence or determine a fact and issue, then we can qualify them. Okay? ER 702. I'm not going to talk about the Fry standard beyond the scope of this class. A lot of people say, oh, what's the Fry standard? So I put that in here, say Fry standard, criminal case, 9-1. But ER 702, this is our rule. We all right with that?
Yeah.
Remember this choice versus
I skipped this slide. Let's go back and look at the federal. The federal standard is referenced by the Daubert case. Hopefully this works. Okay, here we go. So testimony by an expert witness. So a witness who is qualified as an expert by their knowledge, their skill, their experience, their training, or education can testify in the form of an opinion or otherwise if the expert's scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence or determine a fact and issue in the case. Semicolon. So what does this mean? Does we have to do this? Is this enough? If the expert can just do this, is this enough? No. We also, see this is and. So he has to be able to do this. The testimony is based on sufficient facts or data. All right? And the testimony is the product of reliable principles and methods. And the expert has reliably applied the principles and methods to the facts. Is that okay with that? So it gives me all of this criteria, and then we can say, all right, this gets to come in.
So there's no big difference between the state and federal rule as far as the expert testimony?
No, well, with respect to this part right here, no. But on our different level, we talk. If we were to sort of go a little bit more and talk about the Fry standard, there's also that we have this requirement that it has to be, it can't be novel. So under our Fry standard in Washington State, what we say is that it has to be actually based upon the evidence and testimony that the expert is going to offer. It has to be something that's recognized in that particular community. Does that make sense? That is not in this standard here. Okay, so that's a little bit of a distinction between our federal and our state rule. Okay. Where's the mouse? It's frozen. That's weird. Okay, there it is. Weird. What's this thing doing?
Oh, there we go.
I I know, you're bored to death, but let me just get through a little bit more, please.
We can have fun, talk about some that things.
Shoot. Is this your last class?
Yeah.
No. That's West 9 until 9 tonight.
Okay, there we go.
That's what you was meant to do.
Okay, so kind of talk about that.
Criminal procedure. I have criminal, and I have a
Okay. So criminal history. So under 609, so federal part of 609, or state part of 609, we can attack a witness's credibility based upon criminal convictions. Okay? So we're at slide 28. If the crime of dishonesty is not older than 10 years, and if the penalty was more than a year, or at least a year, then we get to bring that in as evidence that will allow us to raise a question about the witness's credibility.
But only if they're the witness.
So it can be the witness or the defendant actually. If the defendant takes a stand. Okay? So the person actually has to take the stand. All right?
But witness or defendant.
A witness or defendant. So any witness or the defendant. Okay? Are we okay with this principle? So it has to be a crime of dishonesty, not more than 2 years old, and at least a year. All right, hearsay. Everybody knows about hearsay. All right, statement other than one made by the declarant while testifying at the trial or hearing offered to prove the truth of the matter asserted. The bottom line, this is the idea of he said, she said, who said it, what did they say it, and why should it come into the court. Okay? Everybody okay with that idea? All right. Now we get some exceptions. I told you, we always have exceptions, right? Here's a little introduction to the exceptions. There are a whole bunch of them. Sometimes they're confusing. They're often misunderstood by lawyers and judges. All right. You're not tasked with memorizing all of these. You simply need to have exposure, general understanding of them. Okay? And some idea about when they might apply. All right? Looking at that?
Is 801, 805 is ER too? Is it ER? 801 to 805?
So ER 801, and then we have some other ones. Yes. So we're going to start at 801. Okay. Admission of party opponents. So, relevant admission of opposing party. We're going to say this is not hearsay. All right? Because essentially, let me explain what this means. So, let's say I'm the defendant, all right? And you were on the stand. Okay. And you were saying, I heard her, she said to me that she was going to, take the money from, she was going to, go ahead and write that check out because she really needed the money. Maybe I'm charged with some sort of bank fraud, okay? Dang, we robbed people today. We doing bank fraud. We just got off the wow.
Yeah, you shot your husband.
And I shot my husband. Dang. Okay.
We have it on.
And we have it on record.
Yeah.
We gotta get rid of this tape.
Sounds like
Okay.
a party.
All right, but you're saying that, okay? Ordinarily, we would think that we would say what? Objection, hearsay. But in this instance, under this exception, we're saying if the offering party may testify to what she heard the opposing party said. Because you're saying, I heard her say this to me. The presumption here is the idea that it's my own statement, and it doesn't mean that we can't raise a question as to whether or not what you're saying is reliable and credible. So we can still cross-examine you on that issue. Yeah. But the presumption here is that when people say things, right, and we're saying they said it, that you see it in the moment, and you tend to it just comes out. And there's an idea that tends to be kind of reliable. Okay? Like I said, it doesn't mean that we can't still attack it. But for this purpose, it's not going to be hearsay. We're going to say, Your Honor, there's an exception. This is an admission of party opponent. She's indicating that this is what she heard the defendant herself, him and herself say. Okay? All right. Prior statements. So again, we're talking about exceptions to the hearsay rule. Prior statements.
I have a question.
Yeah.
What about like texting It's like, say somebody says, well, he texted me this, but I can't prove it because I erased it from my phone or whatever. Is that then, hearsay, admission of party comment?
Well, if you are trying to use it to prove the truth of the matter asserted, then yes, I would argue it is hearsay. I would, and I would raise an objection.
Because you can't prove
Now,
it was that
because
person texting?
Well, no, that's a foundational question.
Okay.
Because there's a whole bunch of foundation that we're gonna have to lay to say, okay, this is a text message that came from this phone, that came from this number, and so forth. So that's a whole layer of sort of foundational issues right there. But I think if I'm on the other side and you're saying, oh, well, he sent me a text message, I don't have the text message anymore, I might be able to say, I could see a court allowing the person to say he sent me a text message. I could even see a court maybe letting in what the testimony about the person, what the person is saying the text message said. But I can also see opposing counsel raise an objection, and I can also see there being that being fertile ground for cross-examination and some questioning about whether or not that's reliable and accurate. Okay? Particularly if, let's say it's a DV case and it was a threat. Ma'am, are you suggesting to the court that you received a text message from the defendant? Yes, I did. And that text message said that he was going to kill you. Yes, it did. And you erased the text message? Yeah, I erased it. Thank you. You know what I mean? Like, really? Remember, she erased it. And so, again, you know, not that it'd be that dramatic, but you can see how that could be fertile ground for raising some issues about the credibility of that. All right, prior statements. Statement previously made by a witness is admissible if witness is subject to cross-examination and any of the following evidence are present. Statement is inconsistent with present court testimony. It's consistent with testimony, but attack has been raised about honesty and motive, or statement was one identifying person after seeing the person. So let me tell you what this means. The idea here is that the testimony that gets to come into the court, right, is going to be the testimony that comes from the witness's mouth while he or she is on the stand. Anything that's outside of court, right, that's said, we're going to call what? We're going to call it hearsay. You with me? And we're talking about exceptions. Under this exception, what we're going to say is that if this witness gets on the stand and they start testifying, yeah, they don't have paper. I saw Angela Patrick when she went into the bank. Yes, and I told I told her before she went into the bank, hey, I don't think this is a very good idea. And she still was insistent that she really needed the money, and she thought that she had a good game plan, and she was just going to go and pass the note to the cashier, and she would have the gun in her pocket, and she asked me to wait outside in the car and just sort of just casually give her a ride home after she came out from the bank with the money. You with me? So this was this testimony, okay? You with me? Okay. So I'm on the other side. Statement is inconsistent with present court testimony. I'm on the other side. And I have in my hands, as a part of the discovery, a statement that she gave to the investigators on the day of the crime itself, on the day that she spoke with them, right? A signed statement, perhaps. It didn't have to be signed. It could just be the statement of police report, right? So now, what do I get to do using this rule? I get to cross-examine her. This is not hearsay. This is a prior statement. We okay with that? Okay. All right. Present sense of impression. Didn't that sound pretty? Statement made during or immediately after an event observed or conditioned. So in other words, a statement describing or explaining an event or condition while the declarant was perceiving the event. Basically, what we're going to say here is that, again, generally outside of court, hearsay. An exception is going to be, this is something that the person said while they were actually doing it. While she was, I saw her, she was taking care of the baby, and as she was taking care of the baby, she was saying, blah, blah, blah. So in the moment, while it's happening, The idea is that, again, if they're saying it in the time, the place, there's something that we presume to be kind of reliable about the things that people say while they're doing the action itself. Okay? Again, doesn't mean we can't raise issues about whether or not that's credible or reliable, but it just means that we might have a potential exception that allows it in. Excited utterance. Present sense impression and excited utterance are often a little bit confused. Present sense impression, I don't have to be excited. It's just that I'm in the moment and there's statements that are being made while that is happening. Excited utterance really is exactly what it says. Oh my God, she just hit him! She just shot him! Ordinarily, we would say that was hearsay. But what we're going to do is we're going to lay some foundation. So at the time that you saw the defendant, shoot her husband, did you hear anything? Yes, I heard her say, I'm going to shoot him. Yeah. Okay. And what was going on at the time? And she was like, she was upset and she was emotional, or I was upset and I was emotional. I was looking at what was going on, and everybody was crying and it was just loud. See how we're trying to get established like the excitement of that moment? Okay? All right, so the requirement of a startling event or condition is not determined solely by reference to the event itself. The event is, the proper focus is the event's effect on the declarant. So how that person is responding to that event, okay? Let's look at an example. Our links have not really been working for us today, but I hope this one works. What is this? What is this? You see how that's all funky? That doesn't look right at all. Let's close that out. Let's close that out. Let's close that. Oh great, now I just closed it completely out. That's not a sign, people. We're just having technical difficulties.
Second sign.
Yeah.
Alright.
That depends on how we take it. Maybe we are taking it as
Ooh.
Sorry, what a reasonable person.
Don't you dare invoke the reasonable person. All right, it's biting me in the butt already.
So we are learning stuff.
All right, hold on 1 second here. I hope that's kind of right. Okay, let's see here. Okay, there we go. Oh, let's put on this and then change it. Please work, please. Please, please, pretty please. Yeah, it's hot. Yes. All right. Oh, you guys can see it, sorry. Keep it as okay. So we have the defendant who's appealing his conviction for first-degree murder. We're so violent this morning, I'm sorry. Okay, so he's saying that the trial court erroneously denied his motion to admit hearsay evidence, okay? He also claims well, we don't have to worry about that. Let's keep going. All right, so let's talk, let's see here. While working off duty, Tukwila police learned that another officer was chasing 6 males from the scene of a shooting, okay? As someone whose name was Wayne, all right? As a result, they arrest this guy and 3 other men. They're all Hispanic, dressed in a manner so-and-so recognized as consistent with this gang. There's some interesting problematic facts here, but we keep going. Man approached her, said his name was Mike, that he had seen everything, and that this person was the shooter, okay? We're okay with that? So we have a witness who approaches and says, hey, I saw everything, this person is a shooter. Let's keep going. They tell him to, tell Mike to stand to the side while she finishes talking with this Babadelia, but Mike left. All right, they later learned that Mike was known to the other officers as Crazy Mike. At the police station, this other person who had been present with their cousin was shot, identified the defendant as a shooter. When interviewed by detectives, let's just call him Bob, denied shooting, but admitted that he was present when another man who looked like him and also named Israel shot him. We got a whole bunch of mess in here, okay? So we kind of got an idea of how messy this is, right? In terms of like, okay, we got some people saying, hey, I saw the shooter. We got another person saying, I saw the shooter, and then they were asked to sit someplace while the officer did something else, and they're gonna come back and talk to this person. Are we okay with that idea? All right, now let's get down to the analysis, because that's the piece that we need. Okay. All right, here we go. So he first claims, okay, here we go. So he first claims that the trial court denied his right to present a defense by excluding evidence of Mike's identification of Bob as the shooter. Remember, Mike is the one who said, hey, I saw, he shot him. He contends that the evidence should have been admitted as an excited utterance or a present sense impression, okay? Because can you imagine, it's a shooting, right? You're in the moment, you say, hey, I saw everything that happened, this person over here is a shooter. That's what, we're okay with that idea? All right, but the court did not let it in. That's why he's appealing. Did I lose anyone? Are you sure? Okay. So the court's gonna disagree. Let's see why the court disagrees, okay? So a criminal defendant has a constitutional right to present his defense. We're gonna skip that part. We wanna talk about the hearsay. Let's go here. Hearsay. A statement other than one made by the declarant while testifying at the trial or hearing, offered in evidence to prove the truth of the matter asserted, is not admissible unless an exception applies. Is that what we spoke about this morning? Okay. Under ER 803, an excited utterance, an exception to the hearsay rule, is a statement relating to a startling event or condition made while the declarant was under the stress of the excitement caused by the event. That make sense? So remember we said excited utterance is basically exactly like it sounds. There's something startling, there's something excited about the moment, and the person says it in the moment. We okay with that? Let's keep going. The requirement of a startling event condition is not determined solely by the event itself, because the proper focus is on the person, right? So the event creates the startling thing, right? But what we're looking at is not just the event, but the effect of that on the person. You with me? Because say there is a wild shooting, right? That is a startling event, right? But see, I'm like, wow, somebody just got shot. That's it. So do you think if I have to say something that's I get to meet this exception? No, because what the court is saying is that it's the event, but it's the effect on the person too. Does that make sense? All right, let's go. Determining whether a statement qualifies as an excited utterance is a fact-specific inquiry. That's the court's very eloquent way of saying what I say to you all the time. It depends on the facts and circumstances, okay? All right. So here, let's go into the court's analysis. So let me pause for a moment. What has the court just done here? Think about your case briefings. What has the court given us right here? The rules. The rules. Does that make sense, everyone? The court has just given us rules. They defined for us what hearsay is, and then they said, but there are some exceptions, and then they've explained to us the exception of the excited utterance. Now, the court's going to do an analysis. Although the statements at issue were made shortly after the obviously startling event of a fatal shooting, right? So there's, yes, a fatal shooting, of course that's a startling event. Nothing in the record indicates that Mike was under any stress of excitement caused by the shooting.
Because he left, he never gave a statement.
Well, no, he was calm. He could be that he left, but he was calm. That's what the court's focused on. There's nothing, it was just like, oh damn, somebody got shot. Wow, that's good. I'm not saying that was his demeanor, but what I'm saying is that there is no excitement. There is not what is expected or anticipated or contemplated by this rule. It'd be different if the startling event happened and I was affected by it. Oh my God, this person just got shot. She did it. Oh, right? Then we would say, Your Honor, that's not hearsay. Okay, Angela, I'm gonna stop picking on you. That, Your Honor, that's excited utterance. We should allow this testimony in. This witness is saying that they saw another person do it. That's not hearsay, it's excited utterance. Here's why we say it's excited utterance. And we have that line of questioning that talks about their demeanor and their response, right? And what was going on with them emotionally and all that kind of stuff to lay the foundation. Did I lose anyone? What? Yeah.
I had a question about it.
Okay.
So the witness reacted right away, like.
What we're saying is that if you're going to suggest that there's a reason for this out-of-court statement that we would normally call hearsay, if you're saying that we should let this in, that we should ignore that general rule and let this come in, then you have to make an exception. You have to show us why what we normally consider to be unreliable he said, she said, why should we think it's reliable in this instance? And under this provision, this idea of excited utterance, we're saying, well, because when people experience a startling event, most of the time there's some effect upon them, right? They're going to be emotionally impacted by that startling event. And in those moments, people tend to speak the truth. They tend to respond to the moment, and their guttural stuff is usually what tends to be consistent with reality, right?
So it has to be a verbal comment made, like, oh my gosh, she shot him, or it can't
Well, it doesn't have to be to that effect, but it's going to be some sort of statement, because remember, that's what we're trying to get in. What we're trying to say is that this witness should be able to provide testimony as to what they heard. And what they heard is X, Y, Z. So yes, we're going to be talking about something they said.
So it should be out loud.
Hmm?
It should be out loud. Sounds like, oh, he got shot.
Well, if I said it to myself, I mean, that doesn't make any sense. Okay? Are we okay with that? Okay. All right, let's keep here. Now let's look at the court's analysis of 803, which is the one about presence and suppression. Okay. All right. 803 provides an exception to the hearsay rule for present sense impression, which is a statement describing or explaining an event or condition while the declarant was perceiving the event or condition or immediately thereafter. So this is what I said while I was actually perceiving the event or doing it. I'm telling you what happened. Well, in the moment, this is where I was, this is what I was doing, and I said to her, whatever. With me? So we don't need the excitement thing that's required under the evidence, okay? But what we do need is that they actually have, this is something that they said while they were actually perceiving the event or doing something, okay? So the trial court determined that Mike's statements to Detective Soltis did not qualify as present sense impression because he made the statements 20 to 30 minutes after the shooting, rather than immediately after. Does that make sense? It's 20 to 30 minutes later, the moment's gone. You weren't in the moment when you said this. You weren't perceiving it at that time, so that's hearsay. Versus this would have been different if it happened immediately after. All right, are we okay with that idea? Yeah. All right. Let's keep going. Another exception, medical diagnosis. So you said it to the doctor, and now we're going to bring it in, and we're going to and try to get testimony or evidence about that. What we're saying is that, well, that's not going to be hearsay because there's a presumption that when you go to the doctor, you go to the doctor because you're sick, right? You have an injury, and you want what? You want treatment. And so the presumption is that because you want treatment, you're probably going to be truthful to the doctor about what's wrong with you. With me? So that's going to be an exception. Recorded recollection. Another exception. Statement recorded when witness's memory was fresh, but witness is now unable to presently recall contents of statement. So basically what this means is that at the time of the incident, there was some sort of statement that witness made, right? That was documented in some form or fashion, okay? Day of trial, the witness is completely and simply unable to recollect. All right? They remember writing the statement though, and using the statement would be helpful. So now what we're going to do is we're going to ask a series of questions that sort of demonstrate, okay, this person is not able to remember independently. And then what we do is move under this rule to allow their statement that was previously made to come into the record as their testimony. Okay? Business records. So hearsay can be based upon a statement, based upon documents, as we've kind of been talking about. The idea here is that your business records, not hearsay, and they are admissible if we can make sure that we meet this criteria. So, what we have to have is a custodian or someone else who's qualified to talk about those records in some way. That person has to offer some testimony that identifies the record and the mode of preparation, like how that record is received in the office and maintained. They also have to give testimony that is maintained in the regular course of that business. Okay? So it's not something that we created just for court. You with me? Because wait, no, that's hearsay. No, this is a regular part of what we maintain as a part of our operation or our business. Okay? Now we do have some exceptions. A lab report, the untestified expert report. Why would we object to this and say this is hearsay? Because who are we going to bring in? Bring in the lab person. Bring in your expert. You don't get to slip that in as a document or ask questions about that as a business record. But we actually, that's something that's a little bit more substantial. Okay. Public records. Exception to the hearsay rule. Because when we're talking about hearsay, what we're saying is that hearsay is inherently unreliable. It's he said, she said, or some paper that we don't know where it came from. All of these exceptions, however, are a basis where the court has established, well, in this instance, it's kind of reasonable. There's something about this, the way that this came about, that tends to lend itself to reliability. You make that statement and you're excited in the moment, excited utterance, okay, we think that's reliable, all right? Doctor, medical diagnosis, you tend to tell the truth when you see the doctor. We'll say that comes in, okay? Public records, certified court documents, we're going to say those tend to be a little reliable, right? Not hearsay. All right. I'll skip over the example. I think that was pretty clear. Other exceptions, former testimony. Again, it's kind of like a court record. We got a transcript. Statement under belief or impending death. We're going to tend to think that that has some reliability. You about to die and meet your maker. People tend to have a truthful moment, right? So while we might ordinarily say that's hearsay, we'll say, again, that tends to have a little bit of credibility to it. All right, let's see here. Physical evidence witness can see, hear, touch, observe, blah, blah, blah. So everything that we classified before as physical evidence, or even the documentary evidence, we built that phrase about foundation. Part of the foundation is that we have to be able to authenticate it. We have to be able to show that what we're seeking to admit, that it is what it purports to be. How do I prove that this is the bank statement, or this is a copy of the check from the bank, right? How do I prove that this, in a drug case, these are some drugs. How do I prove? So I have to be able to somehow basically show that whatever I'm saying this item is, it is indeed what it purports to be. So that's the idea of authentication. Some things are going to be self-authenticating. Can you think of an example of something that's self-authenticating?
Anything under seal?
Huh? Yeah. Our public documents, official publications, a newspaper, a book. Because the idea is that if I hold up a book, right, the book is what it is. It's a book, right? You see that. You follow me? If I hold up a newspaper, it is what it is, right?
It's like, would a passport be self-authenticating?
Nope.
Okay.
Yeah, absolutely not.
It's like under a government seal, right?
If it's under government seal, but unless there's a question about its authenticity. Okay? Other evidence requires writings, recordings, photographs. Does that make sense? So for example, if I was handing a witness a photograph, this process of authentication, ma'am, do you recognize this document? Yes, you do. How is it that you recognize? Well, what is this? Oh, it's a picture of me and my husband, at the beach in Hawaii. Okay. How is it that you recognize this photograph? Oh, because that's me. That's my husband. And how do you know this to be a photograph that you took? Oh, because I see that this is a date stamp that's on the camera that I use, and I see the date stamp right here. So do you see how we're establishing why it is why this picture is what it purports to be and what we're seeing it purports to be? All right. The presumption. So these and these, I think, are absolutely clear. I think there should be a star by this one. It should be self-authenticating. Except where a person is raising an issue about whether or not there's a question about if that's the true and accurate document. Okay, so we've had some cases where maybe the person, let's see, fake passport. Have you heard of that? Right. So if that's an issue, then that probably is not going to be self-authenticating by itself. If there's been some question raised about a particular passport in that case, so we probably might have to have someone from that particular issuing agency to come and authenticate that for us. Does that make sense? Yes.
How do you do that? How do you get something authenticated, like a bank statement? How do you get a bank statement authenticated? Does it have to be
How do we do that? Yeah. And so when we'll talk more about different types of rules. Because this is civil procedure, we'll talk more about different types of rules that will allow us to do that. So for example, when we get to the idea of ER 904, there's one rule that allows us to provide a list of the documents or exhibits that we want to admit into court, but we actually have to attach a copy of those documents too. And we provide those to opposing counsel. If they do not object within 30 days of receipt, then they're going to be admitted. Period. Now we can raise questions about them later on, but foundation-wise, authenticity-wise, all that kind of stuff, whatever, we're kind of admitted. If, however, we haven't used that rule, then what we have to do is lay the foundation. We have to bring in a person from the bank, and we have to have them talk about, okay, so who are you? What's your position? How long have you been there? What do you do in your job? As a part of your job, do you maintain banking records? What do those banking records look like? How do you keep them? Blah, blah, blah. And we show her, okay, I'm going to show you a copy of plaintiff's exhibit number 1. Do you recognize this document? What is it? Blah, blah, blah. That's how you lay the foundation and authenticate. All right, let's see. You guys, we have 9 minutes. I think we can do it. Medical diagnosis, we talked about recorded recollection, business records, public records, physical evidence, we talked about that. Oh, chain of custody. Whatever you want to say, chain of custody. My drug example is a better example of chain of custody. So these are the drugs. I collected them from the scene. I put them into this Ziploc bag. I labeled it. Case number so-and-so, this name, this date, this time. I then passed it off to investigator so-and-so, investigator so-and-so, then logged it into the evidence room. He put it under log number so-and-so and such and such. It went into a locker, it was locked, it was sealed. We have not touched it or removed it until it went to the lab to be tested. When we put it in the lab, you still follow me? Chain of custody. We're showing exactly how it got from the scene to the courtroom now, okay? All right. Best evidence rule. This is kind of less used, but the idea is that if you have the original, use the original. But we also have a rule that says if you have a copy and there's a question about the copy or the authenticity of it, then a copy is just as good. I'm going to skip judicial notice. Stipulations. You will hear the word stipulation a lot in the civil arena. All it means is the parties are agreeing. Okay? So the parties can stip to a continuance. The parties can stip to the admissibility of this piece of evidence. Okay? The parties can stip to this jury instruction. They're agreeing that as to some aspect of the case. All right? Other terms, burdens of proof. We've talked about that. Affirmative defense. Defense that argues defendant is not liable even if plaintiff's claim assumed to be true. We will talk more about affirmative defenses, but that's just your general introduction. Presumptions. We'll talk more about these, but this is the idea that the jury can presume presume something to be true based upon some indirect evidence, but they are generally rebuttable. So let me give you a quick example. I used to use a case all the time called the Ryan case. It's the case where a teenager went to a party at another teenager's home. The parents were there. They were engaged in some underage drinking. The child leaves. She came to the party by car. She left by car. She was involved in a fatal car accident. Okay. The parents of the child who died filed a lawsuit. They were alleging negligence, right? And what they said is that, well, because we have a law that says you don't give alcohol to minors, we should be able to tell the jury there's a presumption of negligence. We can presume these people were negligent because they violated the law. So we start out with that fundamental presumption, and now it's the defendant's burden to kind of shift that. Doesn't mean it can't be overcome, but that's the idea of a presumption. Okay? You guys, that is our general introduction to evidence. We're going to come back in and tie these things down. Remember, the expectation is not that you're going to remember all this stuff, but you do need to have some basic foundation, okay? You'll see when you look at your quiz, you just have a couple of questions that relate to this. So when you take your quiz, remember it's not timed. You can look at your resources. While it is open book, it's not group work, so do independently do it, okay? All right, that's class for today. Have a good weekend. I'll see you on Monday. Okay, cool.